Hi, folks. I'm Denise Howell, and you're joining us for This Week in Law. We're so thrilled you're here today because we've got a great show for you. Our guest is Thomas E. Delahanty II. He is the former U.S. Attorney for the state of Maine. Mike Keys and Matt Curtis are here as well. We're going to talk about the new iPhone. It's disabling of Touch ID at the request of the user and its implementation of facial recognition technology. We'll talk about assets seized from Kim.com. Can you be a fugitive when you've never stepped foot in the United States? We'll look at IP rights related to textures and aromas. All this and much more on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is TWiL, This Week in Law with Denise Howell, Matt Curtis, and Mike Keys. Episode 398, recorded September 8th, 2017. Pumpkin-flavored justice. This episode of This Week in Law is brought to you by Felix Gray. Give your eyes the break they deserve. Felix Gray glasses filter blue light and reduce eye strain without the ugly yellow tint distortion of other computer glasses. Go to felixgrayglasses.com/TWiL to try a pair today. Hi, folks. Denise Howell here, and you're joining us for This Week in Law. We're very excited that you've picked today of all days to join us on the show. We have a very special guest with us. Our guest today is Thomas E. Delahanty II, Tom, as he goes by. We promise not to make him feel like he's in elementary school English. He has had an illustrious career both as a state prosecutor and state judge in the state of Maine, and he has served until recently 2 terms as the U.S. Attorney for Maine. He also has the distinct pleasure of being the dad of one of our TWiT family, Patrick Delahanty. Tom, it's so great to have you on the show.
Good morning. I'm very happy to be here.
Also with us are my 2 wonderful, wonderful co-hosts, Mike Keys from the Dorsey firm in Seattle. Hello, Mike.
Hi, everybody. Great to be with all of you and thrilled that Tom is here with us today. This is going to be a great show.
I know. I'm excited. Matt Curtis is here, too. Matt is a law student at Notre Dame. Hello, Matt.
Hi, Denise. Great to be on again, and really thrilled to have Tom to learn from his knowledge and expertise.
Me too. Let's get right into it. We're going to start. We have so much we can talk about with Tom, and I hope to cover a broad range of topics with him today, but we're going to start in the realm of privacy. So, Tom, perhaps maybe we could start out before we jump right into our stories with you giving us a bit of an overview, 2 terms as U.S. Attorney, which for people who aren't familiar with that term is the chief federal prosecutor resident in every single state of our United States. You served in Maine. And I'm sure people are interested. Obviously, that puts you in charge of the prosecution of a myriad of federal crimes. We here on This Week in Law and at the TWiT Network tend to skew our interests towards things technological. So I was wondering if you could tell us how you saw technology impacting the kinds of cases you were handling over your two terms in that role.
Well, the first opportunity I had to serve as United States Attorney began in the Carter administration. And that, because of politics, lasted about 15 months. And then I had another opportunity during the Obama administration. So in the intervening 30 years, approximately, there was a tremendous change in the types of cases that were being handled and the way that the cases had to be handled. And most of it really had to do with technology and computers. And when I got back into the U.S. Attorney's Office in 2010, almost all the crimes have some technology aspect to it, whether it involved the use of cell phones, by the criminals. They were using emails. They're using their own, networks of one kind or another, and and also it creates a fairly large international component. Previously, in order to commit a crime, the people almost always had to travel to some part of the United States or United States territory. But now there are so many situations where they are committing criminal crimes in the United States, but they never come into the United States. My office, and we had a relatively small office, not like some of the metropolitan areas as you have here in California or New York or Florida. But we were doing international crimes, sometimes in the fraud angle, and also when people were getting involved with child exploitation. Our office in Maine was prosecuting cases that originated from the Philippines. One of the assistants that worked for me just got back from Peru, and we've done cases from England and South Africa and other parts in Eastern Europe. So, but it's really changed, and it creates a whole different component with the cases that are taken on.
Right. So if I'm hearing you correctly, you're saying that your defendant base has gone international thanks to technology.
It has.
That you need to have the resources to go abroad and hold people accountable under the U.S. justice system in ways that we never had to consider before all these technological tools were available to us. We were just talking about this on last week's show a little bit in connection with the glasses that people were purchasing for the solar eclipse, many of which were manufactured in China and elsewhere, and some of which were counterfeited in China and elsewhere, and to many people's detriment, as their eyes got damaged because they thought they were using a legitimate product, but they weren't. So it's just one of a host of examples of ways in which that's not really one where technology was so much involved. But I'm just wondering if you could shed some light for us all on what's a federal prosecutor to do. How do you go after those folks?
Well, that becomes very difficult. If they're counterfeit, it's a company that is not going to take responsibility for the product. If they're producing a legitimate product, they want the people to know that they have a good product out there and to sell more of it. But if it's counterfeit, they're going to do everything they can to hide their identity. And then it becomes very difficult to investigate in those other countries. Some of the countries are extremely helpful when inquiries are made, and others are reluctant to get involved. So it's a difficult process at times.
I'm sure it is. All right. Well, we did promise you some privacy stories, so let's get into those. Let's talk about Touch ID and the Apple iPhone. Tom, I'm sure you were following along earlier this year with the controversy about the FBI seeking access to a phone of a deceased suspected terrorist here in California, and the controversy that developed around whether Apple should be forced to open that phone, and the extent to which locked devices can be accessed by law enforcement and the parameters for doing that. We have a new development now in that complex dance of technology, law enforcement, and the tension between the two, because it appears that the next iteration of Apple's phone operating system will implement what's being called a hot button, which disables Touch ID altogether and makes the phone require a password in order to be opened. And the reason this becomes important is because courts have struggled with the Fifth Amendment and how it relates to all this. And while I'm vastly simplifying the complexity of the judicial decisions out there, as a rule, if you can kind of distill those down and not get too deep in the legal weeds, you can be compelled by law enforcement in some or most instances to provide a fingerprint to unlock a device. But if you're withholding your passcode, that is deemed to be testimonial. That is deemed to be something that is protected by the Fifth Amendment, and you can invoke the Fifth Amendment to not incriminate yourself and decline to provide the passcode itself. So the new technology coming out from Apple, we believe, if the rumors are right, will and developers have tested this out with early versions of the operating system. They say this is how it works, that you can depress the wake sleep button 5 times, and that will disable the biometric entry to the phone and make it require a passcode. It will also enable you to call in. It will enable you to call 911, as I understand it, if you swipe right, and also to access a list of your own emergency numbers. So this is like a panic button kind of feature. The scenario I think the developers are probably envisioning is someone who is intending you harm is forcing you to unlock your phone with a finger or what have you, and you can thwart them and call for help by activating this 5-button push on the wake sleep button. How do you see this, Tom? Do you see this as a quote unquote cop button, and how do you think law enforcement will respond?
Well, first off, I think it's unfortunate that it's being referred to as a cop button. That may be one of the uses and protections, but I think there are other situations where somebody might want to utilize it to protect it from somebody who is seeking information from them who may want to do them harm. It may be somebody that they're having some type of a dispute with. But there are a number of ways to get into phones, and people, I think, do need to have the right to protect their information. Now, as you said, there does come a clash between law enforcement and some of this information and privacy rights when people are alleged to be using it for criminal means of one or another. The police do need to investigate, but they are not going to be able to get into the phones whether they, without a warrant of some kind. So they're going to have to go to the court and show the necessary probable cause. Now, when they do get the phone, and if it is accessible with the Touch ID, they can do that. And some courts have said that that is not a violation of the Fifth Amendment. But if they require somebody to, in one way or another, speak or to utilize the passcode, that would then implement the Fifth Amendment. And the law, as you know, over years changes. And this is a new area that, as you said, a lot of courts are struggling with. It's technology where there is not a lot of legal precedent. And there are many situations where decisions have been made by courts, and then another court will have a different view. So it's going to be a complicated area. I think the Supreme Court is going to have to clarify eventually, when they get the right cases, how far this is going to go and how far law enforcement can go into this. Now, as far as the case you were talking about from San Bernardino, in that situation, the users or owners of the phones were deceased. And the question, I think, then comes, how far does do privacy rights extend after a person has died? Do they still have those when it is necessary or very important for the law enforcement to get some background information that would shed light on possible other situations?
Yeah, excellent points. Mike, what do you think about this rumored new addition to iOS 11 that would disable Touch ID on the user's request?
Yeah, I think I stand with Tom on this one. I mean, it seems like that functionality could be a welcome change. And I find it a little bit unfortunate that it's being referred to as a cop button, because I could definitely see a situation where someone's facing imminent harm, not from the police, but from somebody else, and they want to disable their phone. And as you mentioned, Denise, you can tap the home button 5 times, swipe to the right, and it automatically calls 911. You don't have to dial 911. So I could see that being very useful and a practical tool for someone to have literally at their fingertips. In terms of the law enforcement angle, I'm always, and we've talked about this numerous times before, and I get what the courts have said, that there is a distinction between being compelled to essentially provide something that you have, i.e. a fingerprint or a blood sample, versus being compelled to provide something that you know, like a passcode. One, the first is not considered testimonial, but the other one is considered testimonial. At least that's we've seen court cases come down both ways. But it seemed to me, at the risk of sounding like a simpleton here, Tom, I mean, it seems to me that the distinction is, I wouldn't say meaningless, but I'm having a hard time understanding what the distinction is there, because at the end of the day, the result is the same. You're going to get the information on the phone, and whether that is by providing being required to provide a passcode, or being provided to provide some sort of biometric data that unlocks the phone, it's the same thing. So it would seem as though that the analysis should be the same. But again, I am probably sounding a bit like a Fifth Amendment simpleton here. But I just don't. I've never really bought that distinction between those two concepts.
Well, it comes down to really providing the knowledge that somebody has in their thought process, their memory. But if they are looking for a fingerprint, that can be likened to a situation where they get a warrant, perhaps, and a court order to obtain a DNA sample, whether it be a blood sample or a hair sample or a swab. And here they're looking for a fingerprint. But if somebody is required to punch in their personal code, passcode, then that's more like when the police might be interviewing or interrogating somebody, and rather than having them voice their knowledge, to write it out. That's pretty much the same thing. I think that's the major difference there. It's kind of simplified, but there are times, when the police want them to write out a statement, and if they haven't been provided the proper warnings and given the opportunity to refuse to do so, then that's improper. And I think the passcode would fall into that category.
For people who want to go deeper on this issue and better understand it, because it is confusing, why there should be a distinction between providing a fingerprint, or I should mention other body parts. In looking at the stories around this and the analysis around it, particularly from Oren Kerr, who writes for the Volokh Conspiracy at the Washington Post. He's a law professor. I learned, and I didn't know this before, I guess I sort of thought in the back of my mind, sure, it doesn't have to be a thumbprint or an index fingerprint, but it can be all manner of things. Apparently can be used, all manner of body parts can be used to lock and unlock an iPhone, and I presume other phones as well. If you look at some of our discussion points for this week, which are all available at tagpacker.com/user/thisweekinlaw, we're episode 398 this week. You'll see some very interesting examples illustrated by videos, et cetera, in some of the articles from 9 to 5 Mac and elsewhere, of people who've used their toe and their dog paw and their nipple and their nose to successfully lock and unlock their iPhone using Touch ID. So I suppose that would be yet another added level of security. I don't think the Fifth Amendment analysis would change. But if you are interested in more detail on that Fifth Amendment analysis, I would encourage you to go read some of Professor Kerr's writings on this, where he gives some examples. The one that sticks in my mind is a police officer doing an investigation. There is a room full of people at a crime scene and a phone, and it's not clear who is the owner of the phone. And the question becomes, can they all be compelled, or can any of them be compelled to put their finger on the phone to unlock it, or their toe, or whatever it may be? And, the analysis that he does there says no, because even though lots of courts have found that fingerprints are like blood or hair or other things that are non-testimonial, the mere act of you saying, basically raising your hand and saying, "That's my phone," that's testimonial. So if there is no quote unquote foregone conclusion, and I guess there is a foregone conclusion doctrine in Fifth Amendment analysis, if it's clear whose phone it is, then perhaps it's not testimonial. But if it's not, if that's still a puzzle piece waiting to be put in place, then you may well have a Fifth Amendment right not to volunteer any information, not to put your finger on the phone, etc. So go delve deeper in those articles if you're interested in doing so. Matt, as I go through this, I tend to be on the same page with Mike to some extent, that I do feel like it's a strange distinction to make, that there's not something, terribly testimonial about your numeric code that unlocks your phone, as opposed to your fingerprint. That whether you have volunteered your numeric code doesn't say anything necessarily about whether or not you have committed a crime. So it's hard for me to make that intellectual leap too. But the other intellectual leap it's hard for me to make is to think that there are going to be a lot of people who go ahead and update, first of all, go through the update process to their iOS, right? If they're not getting a new phone when Apple rolls out the iPhone 8 soon, if they're simply updating their operating system, many people don't do that. And even if they do, the four of us and the folks in the studio and the folks listening are among the small group of people who are going to know about this disable Touch ID feature, right? Does that matter at all? That maybe it's just the people who really want to conceal what's on their phone who know the feature exists.
Yeah, and even for people who really want to conceal information on their phone, this is a worse way to do it than just having a passcode. So if I'm a sophisticated criminal organization and my low-level employee, or whatever you want to call them, says, "Hey, I got this new thing and I can press this button 5 times and the cop get to me," I'm going to say, "Well, no, just use your passcode," because then they can't get it at all. So I really don't see the value even in that hypothetical like cop button situation for the criminal organization. I think that this is one of those things that people are talking about in terms of its value to protect privacy and all of that. Ultimately, I can see little value. And the question from a public policy standpoint is, when a cop is coming up to somebody, do we really want them reaching in their pocket to try to touch a button 5 times? It seems like you're going to have the situation where it's going to look like they're going for a gun, and that's not a good thing. So, for both parties, I think that's just a terrible situation. To the second part, I think that the distinction intellectually, and I'm not an expert on this, but it seems like the Constitution is written to limit powers, to enable and limit powers by the government. So we're not looking at this in terms of how it incriminates me as a suspect, or does not incriminate me, but what law enforcement agent would be able to do. And I think that the Fifth Amendment actually is a limit on this specific clause of the of the Fifth Amendment, which says nor shall be compelled in any criminal case to be a witness against himself, is actually rooted in a prohibition on torture. If you look at 16th and 17th century England, that the practice of compelling testimony was well used, and so that the American founders said we're not going to allow torture. And so, looking at it from that perspective, the distinction between trying to get information out of your head, which is something that you cannot be persuaded to do if you're determined not to, and therefore it would require the use of some sort of torture in order to get it out of you, where something evidentiary on the outside of your body. So they say, for instance, an easier example is a suspect is identified by their tattoo, and so it's under their shirt. The question is, could they get under the shirt to look at the tattoo that's been identified? And I don't think there's any problem with that, and I think that that's the distinction. It is what the Fifth Amendment is actually built around, and I think it makes sense from that perspective.
Yeah, I totally agree with you. I think that's a great way of framing it. Tom, do you have anything you want to add?
Well, just one of the things that Matt brought up is really not a legal point, but it's a very practical point, and that is if somebody is confronted by a law enforcement officer, especially if it's kind of a heated situation and they reach into their pocket just for their cell phone. We've seen too many situations turn ugly when a person is doing something suspicious. And that could be considered, especially if they've been ordered to, quote, keep your hands where I can see them. And then they reach into their pocket, could lead to some unfortunate circumstances.
Hey, Victor in the studio just brought up a good point that is probably on people's minds that we should mention in the context of this discussion. It's a little bit different than Touch ID and things we've been discussing, but I'm sure everyone has fresh in their minds this nurse in Utah who declined to comply with an officer's request for a blood sample from an unconscious patient. The spin there, the twist there is the hospital, and possibly, I'm not sure if this is every hospital in Utah or that particular one, had an agreement, an understanding with law enforcement that they would not be taking blood from unconscious patients. And again, I think the warrant process comes into play here. I'm not sure if this particular officer had a warrant or not. The way that it all went down and the fact that there were so many apologies after the fact lead me to believe that no, there was no warrant in that case, and that the nurse was standing by the hospital policy and agreement with law enforcement. The way that they had decided they were going to go forward in these instances was to not give access to blood samples of unconscious people. So it's a slightly different analysis because of the way that they had agreed to proceed, and she was simply trying to comply with that, her understanding of that agreement, and the officer didn't like the agreement and wanted her to comply. So I'm not sure that there's a Fifth Amendment overlay here. Tom, do you agree?
Well, there are some situations in some communities where the local police will have an agreement with the hospitals, especially in life or death situations or situations where a warrant has issued. Many police departments, when they need some type of sample drawn, have certain medical personnel that they might go to. But having a warrant really makes a big difference. And even if they had a warrant, it authorizes the taking of, let's say, a body sample of one type or another, and but it doesn't necessarily require the hospital personnel to comply.
Right.
If they do, they would, I believe, always be protected because they were acting pursuant to a warrant. But I don't think they can require them. And if they get a medical personnel who says no, I think they kind of have to search around until they get one who will assist them.
Right. Or I mean, I suppose the police could bring their own forensic medical personnel in with them, correct? If they have a warrant and they know they're entitled to a blood sample, they would bring their police authorized and employed sample taker with them.
In some circumstances, they could probably do that, but a lot, I think, would depend upon the protocol of the individual hospital, because they might not want somebody who's not on their staff coming in taking various samples. And there are some states, just in a regular routine DUI case, where they want to get a breath or blood sample from the defendant, and many states have implied consent, where if you have a license, you have to do it. But the person, for instance, in the state of Maine, they can say, I would like a blood test, and I would like Nurse Smith to do it. And then, they would call Nurse Smith, but she has no obligation to come in and take it.
Got it. All right. Thanks for elaborating on that for us. Let's stick with phones for a moment and talk not about the operating system, but about the hardware. There is a rumored change coming with the iPhone 8. As I understand it, Samsung already has this technology in one or more of its phones, and that is facial recognition as a way of unlocking the phone. So instead of your nose or your dog paw or your finger unlocking the phone, you would point the phone at your face and have access to what you needed. This is a bit of a twist. In some ways, it's similar to using other body parts, and in other ways, it's unique. A lot of privacy and security personnel don't like the way that they think this has to work, which is to have the facial recognition feature, I assume triggered by the camera, always on, looking for that face that will unlock it. So they're concerned that of the data gathering that needs to go into that and the management of that data. They're also concerned that someone's face is far more easy to gain access to than their fingerprint or their toe print, especially in the era of selfie sticks and Instagram. And if you wanted to fake your way in using somebody's photograph, it seems like that would be something that perhaps you could fool the phone into doing. Tom, do you think this changes the analysis at all?
I'm not sure it'll change the analysis too much, but I think a lot of it depends upon how the process actually works. And if Apple is going to be doing it, we don't know exactly what is required and how it will technically work until it is out there. And I'm sure that once it gets out there, changes will be made as various problems creep up. It's clearly, I think, a work in progress. Legally and technology. Yes.
I love one quote from the piece that Mashable wrote on this, quoting Dan Tentler, a security researcher, who says, where does he start here? If consumers are using their faces as a form of authentication, but doubly are the types to buy selfie sticks and littering pictures of themselves everywhere, it's like setting your password to password, then tattooing it on your forehead. So I think he's got a good point there. What do you think, Mike?
Yeah, I noted that. I thought that was funny. Yeah, I think Tom's exactly right. The devil's in the details here. I mean, we don't know exactly how this is going to operate. I mean, there are a couple of potentially troubling aspects I could see. The fact that this facial recognition feature may always be on, which would apparently record any data or anybody's face that happens to come across your phone. I suppose that could be a bit troubling to folks. But then I think the other thing that is potentially problematic, and again we'll see how this all plays out. What happens is this information stored locally on the phone, or does the imprint of your face or the digital imprint of your face, reside on some server somewhere, and is going to be saved and could be accessed. I mean, that's something that I think people might be legitimately concerned about. But but we'll see. On the other side, I could see people really liking this this functionality. You just look in your phone and it opens up. You don't have to fiddle with the button or put in a passcode. So, there's some benefits to it too. But we'll see.
Right. Matt, presumably this turn off Touch ID feature that we've been discussing up until now would have a parallel turn off facial ID feature if you did not want some person who intended you ill to access your phone simply by holding it up to your face.
Yeah, and I think that there's even simpler ways to handle that situation. One, going back to the image recognition software would always be on. It's kind of inconceivable that would be so. Your battery drain would be so significant that your phone would probably die in an hour or two. So as a consumer standpoint, I just can't imagine that's true. So I think that there's going to have to be in the same way that you touch your phone in order to put in your passcode, I would imagine that the image recognition will only turn on there. In terms of Mike's question of whether it be stored locally or on a server, typically the breakdown within image recognition software is at about a 10,000 mark. So if it takes less than 10,000 images to recognize your face, which very much assuming it would, I would imagine that it would digitize like a couple hundred of them so that it could give you with different looks and such to be able to let you in, that it would be stored locally rather than over the server. That there's battery incremental battery gains through that. And then third, to the point of where can this technology go, and I think this goes to Denise's question, is that your eye movement could be a tracker for the passcode. So you could have to blink a certain number of times to let yourself in, because image recognition isn't simply an image in the sense of like a still image, but video capture and timing of that. So this could significantly be an improvement from a fingerprint, although I don't think it's ever really going to be better than being able to use a number system. I think that's just a more secure passcode.
Right.
Matt,
Tom,
you raise a really good question. Is can law enforcement compel you to blink several times into your phone? Would that be considered testimonial? Who knows?
I think that would fall on the other side of the line because it's much more like a passcode. I also don't think they can they can't actually compel you to do that because they wouldn't know what the specific code of your unlock is. So it's a knowledge-based thing.
Right.
And
I'm with you.
Yeah, these are all questions that I think we're going to be finding out about in the next several years.
Tom, I'm wondering if your special knowledge as a prosecutor, and of course I'm not asking you to reach any security clearances here, but one point that was also raised by that same security reacher in the Mashable piece is this point that we mentioned a moment ago about the phone potentially gathering a ton of facial recognition data and sending it off to your phone manufacturer's databases, and from there being accessible to law enforcement and potentially hackers who have reasons to want to have large facial recognition databases. Years ago, Scott McNeely got in trouble for telling people, you have no privacy anyway, get over it. Is this one of those scenarios where, if the government wants to match up your face with your identity, it can already do so, and this doesn't really make a difference?
Yeah, there are other ways to do it. But when the various companies are gathering the information, there have now been created very strict protocols in order to gather information from any of the data companies, whether they be manufacturers of phones or web servers or anything else. The Justice Department has their own procedures that the prosecutors have to go through to make sure that, number one, there's sufficient reason to do it. It's just not a hunt for some information about a person because the prosecutor might be curious or think that somebody is involved. They've got to come up with the process to do it. And any assistant can't just decide they're going to start an investigation. They're going to have to come up with the background and sufficient cause for it, and then go to the superiors. And in some situations, they're going to have warrants, and perhaps even something as much as an indictment in order to get some of the information.
Good to know. Before we move off the privacy topic here, you personally, Tom, had some brush with the federal government wishing to protect your privacy in the context of your resignation from your position as U.S. Attorney. Maybe it would be helpful for you to describe. You alluded earlier that you had held the position of U.S. Attorney for Maine earlier on under the Carter administration. For folks who aren't terribly familiar with how people get that job and keep that job, maybe you could start from square one and describe the political appointment process and what happens when we have a change in administration.
Okay. Well, more recently, as I was terminated, I had a friend say, "Gee whiz, it's too bad you have to lose your job because of politics." And my answer was, well, that's kind of how I got the job in the first place, was a little bit of politics being involved. But every person who is appointed to this position, and there are 93 United States attorneys. Many states have one, and some of the largest states like California have, and Texas and Florida have as many as 3 or 4 United States attorneys divided up into districts. Generally speaking, when there is a change in administration, you expect that your term is going to end, even if it's the same party, because the president who is coming in has a right to appoint the people that he or she would feel would be appropriate for the job. Most often it is when there is a change in political party. 35 years ago, when that happened, when Reagan defeated Carter, I had been there a short time, but I knew that there was going to be a change. And not long after the inauguration, I did submit my resignation. And one of the options we were given was to submit your resignation effective on the appointment of a successor. And that's what I did, and I was able to stay until about mid-August. A new person was appointed, whom I knew very well, and when he got sworn in, I left. But it led to a smooth transition. The office was a lot smaller then, but I was able to work with the people in the office and plan for moving the cases on with a new person as United States Attorney. And the United States Attorney is the chief federal law enforcement officer in the state. Not that the U.S. Attorney or even the assistants are going out doing investigations, but we oversee policy and procedure. And each administration is responsible for perhaps bringing in their own particular policies regarding certain issues. And when the opportunity came more recently after President Obama was sworn in, I was one of more than a dozen people who were interviewed for the job. I was one of 4 people whose names were sent to Washington for consideration. I was fortunate enough to be selected, and then you go through a vetting process, interviews. But from the initial interview until I was actually sworn in was about 17 months. And Maine did not have a Democratic senator at the time, and the states with Democratic senators were generally getting taken care of ahead of time. But I was about in the middle of the pack as far as the numbers are concerned. And but once I got there, some of the things were very familiar, but mostly because of technology, the actual prosecution of cases and the investigation of cases had changed so much. And then what happened this time, the United States attorneys, had the choice of, for a while, whether we wanted to stay or leave. Approximately half of the United States attorneys had resigned and left to go into other positions. Some went into teaching, some into private practice. Either before or shortly after the inauguration, there were about half of us who, having been told that we would have the opportunity to stay until a person was named and approved to succeed us, that we decided that we would do that because in my personal case, I thought it would help the transition. I would be able to finish up some of the cases that the office was working on, and but then eventually a new U.S. attorney would come in, and perhaps there'd be some changes in policy and procedures. And then it was completely unexpected that we would be terminated so abruptly. I actually was on vacation with my family in Florida, and they got a phone call saying, we expect your resignation by midnight tonight. I didn't get it to them until the following week because they wanted it mailed. I didn't have access to my computer or printer, and I was terminated anyway, so it really didn't matter when the actual letter went in. And but what happened after that, I think it was about mid-May, the USA Today and some of its subsidiary newspapers were seeking to get a copy of the letters that we sent in. I don't know if I don't know specifically what they were looking for. Maybe they were hoping for some pithy remarks that people made about the president of the administration. But the Department of Justice would not release the letters, saying that there was too much personal information. Letters of resignation were personal. And that was really a surprise to, I think, many of us, and certainly the ones that I talked to, who my letter said, basically, I resign as instructed. It was a pleasure to serve under the Presidents Carter, Reagan, and especially Obama, and I resigned. I do know another U.S. attorney that I talked to expressed a surprise for the time and did mention that it impeded an orderly transition. But the Justice Department would not release them, saying there was too much personal information in there. I was eventually contacted by a reporter from the Burlington, Vermont Free Press, which is a subsidiary of USA Today, asking if he could get a copy of my letter. And I said, yes. And I sent him a copy, as did another U.S. attorney. And the only thing I did is I deleted my personal phone number, personal email, and home address, more for security reasons than privacy. But, I mean, it was public knowledge that I had been let go. And, you know, every U.S. attorney knows that when you are originally appointed, you don't have the job for forever or going into new administrations. Virtually all of the U.S. attorneys were allowed to stay in when President Obama was reelected, but that's kind of the practice. And it can vary from administration to administration. And if the present administration had asked me and other U.S. attorneys to please resign by the day of the inauguration on January 20th, we would have expected that. What happened here was, having been led to believe we would be able to stay for a while and help on the transition, the suddenness was very strange. And then these newspapers, they have a FOIA request into the Justice Department that I understand has not yet been acted on, and it may be leading to litigation. Then that's pretty much what's happened. So in 46 United States Attorney's offices, the person who had been acting as the first assistant became the acting United States Attorney. So it was the suddenness of it that really surprised everybody.
Yes, I'm sure that was surprising and was not quite as orderly as the way that you came into your job. And it seems strange to me that, as you say, there's no way of knowing what was in all of the letters, and maybe there's something pithy in there that some newspaper would be anxious to report on. But strange not to just make them public. I can't imagine there's anything too controversial in there. But as you say, perhaps someday the FOIA requests will be analyzed and a court will weigh in on whether or not the personal privacy exemption to FOIA applies here, when personal information such as you removed from your letter could easily be redacted from these things. Do you have any thoughts, Mike?
Well, I was just wondering, Tom, if you know or if you're at liberty to say why this happened so quickly. As you mentioned, 46 U.S. attorneys across the country all at once received this notification. Any insight there that you can share with us?
Well, there's a lot of speculation that these former U.S. attorneys have offered to each other, but it's not something that I can discuss because nobody in the department consulted with any of us, so we don't know the exact reasons.
Matt,
Sorry, Denise. So
no.
Most, if not all, of these positions are still unappointed. Is that correct?
I don't know the exact number, but I do understand there are about 4 or 5 that have were confirmed before the Senate went into recess. One I do know certainly is John Huber in Utah. He was a U.S. attorney under Obama. He did resign, but later was nominated and has been approved. But that's a rare case. And I do think there are a number of others that are in the pipeline. I know the person who has been named as my successor, his nomination has been moved on to the Senate Judiciary Committee. And I also know that there are some states, Rhode Island, for instance, or all of the New England states except Maine, do not have any Republican senators, so that none of their nominations have moved forward. And so it's going to be a while before somebody is appointed there.
Matt, do you have any thoughts or questions on this?
No, I'm just interested to learn about the process.
All right, then. I think we need a passphrase in the show at this juncture. We put these phrases in for those of you who would like to demonstrate that you actually watched or listened to the show. If you are interested in seeking continuing legal education credit in your jurisdiction or professional credit in another field besides law, we put these phrases in to give you a hand in case you have some oversight body that needs to know that you watched or listened and didn't just put episode 398 of This Week in Law down on a list somewhere. So our first passphrase is going to be unlocking by dog paw. And at some point later in the show, we will put another phrase in. So jot these down if you are enjoying the show with us for that purpose or as an added purpose to your enjoyment of the show. Let's move on and talk next about crimes and justice. Tom, we're hoping that today you can give us sort of a primer on asset forfeiture, which I understand is something you're interested in and know a bit about in your capacity as a former federal prosecutor and as a former judge. there is a technology story in which this issue is front and center, and it involves Kim.com, the founder of Mega Upload, which was a site that the federal government went after for hosting illegal downloads of movies and software and various other things. Kim.com went off to New Zealand, where his assets there and in the U.S. have been seized. He has a cert petition to the Supreme Court, our U.S. Supreme Court right now, challenging the seizure of his assets, pointing out that the legal battle in which he is involved is an expensive one, and he could use access to those assets, and also arguing that perhaps the steps taken here were overbroad and threaten the rights of any person residing outside the U.S. who may not even be a suspect of a crime. So maybe you can give us the parameters of how this works, and also try and ballpark for us, if you will, how you think Kim.com's cert petition will fare.
Well, I think to guess how the cert petition will fare is a guess, and so I wouldn't venture an opinion there. But as far as asset forfeiture is concerned, it falls into two categories. One is the civil asset forfeiture, which is actually the side that has caused the most controversy, because the government, under some circumstances, has the opportunity to seize assets of various types without charging somebody with a crime, although there does need to be some type of illegal activity taking place. The second side of it is the criminal asset forfeiture, where assets of one type or another can be seized because they are related to the way in which the crimes were committed, or could be the fruit of the crime. And that is the more common one. And it can be anything such as the automobile that a drug dealer was driving when the deal went down. But it can be automobiles, boats, planes. A lot of times there are firearms involved. And in many situations, the profits, if they're able to get the money on get the hands on the money that was made and was the profits out of the illegal drug deal. So there are two sides, and they have actually different process that they have to go through. The Obama administration, when Eric Holder was the Attorney General, took a number of steps to try and tighten up the civil side, that it was a little bit more difficult, it would become a little bit more difficult for both federal and state to seize the property if there was not going to be any criminal activity. In some states, that particular jurisdiction has very limited asset forfeiture statutes and laws, or they have none at all. So the state would then go to the United States Attorney's Office or one of the federal investigative agencies and try and link their case with them and link their investigation to get a seizure under federal law. But there does need to be some evidence and more than suspicion that these people, in order to get these profits, were engaged in some type of criminal activity, but there might not be enough evidence to get the probable cause or enough evidence to convict somebody beyond a reasonable doubt of a crime. Under the Obama administration, it became far more restrictive, and that in order to take on a civil asset forfeiture, generally called an adoptive case, one that was developed by the state authorities, one prerequisite had to be that it was linked to a federal investigation, or there were federal agents who were actually working with the state in conjunction with them to do the investigation. There are these monies are then, once they go through the judicial process and there's a judgment and a formal forfeiture of these, are then the money is distributed to all of the law enforcement agencies that were involved. Generally speaking, the Justice Department or through the asset forfeiture group, or the Treasury Fund operated by the IRS, which basically serves the same process. They would then divvy up the money among the agencies who had participated in whatever the investigation was, reserving 20% of it for the federal process to cover the expenses of processing the case. On the criminal side, it's easier for the federal government, and you can see whether a major crime has been committed, that you can justify taking those assets much easier than somebody who has not been charged with a crime. And they range from millions of dollars, for instance, in a Bernie Madoff situation, to seizing money from a local drug dealer. There's some of the restrictions put on during the term of Eric Holder. They really wanted to make sure that they were justified, and to give more and to prevent some abuses. And there were a number of cases cited where state law enforcement people or county law enforcement people, they would seize a vehicle that was suspected of being involved in drugs, and including a fancy sports car with dark tinted windows and out-of-state license plates, driving down perhaps speeding so they could stop for speeding on the interstate, and they find some marijuana in the vehicle, and then they cite that that's enough to seize it, but there are no criminal charges, and then the vehicle ends up being used by law enforcement. That's kind of an extreme example, but there are situations where money was seized on a civil basis and with very little and no criminal activity alleged with it. And there is a process where the people can contest it and go into court and petition to get the money back and whatever the asset is, and sometimes they do, but it's long, and it puts the burden on them to show that whatever the asset is was not generated by any illegal or criminal activity. It is a process by which the government can not only arrest and prosecute and convict certain criminals, but it also is designed to take away the profit motive from a lot of their activities and to discourage them from doing that. But I think in my experience over the time that I've been involved in criminal justice is that many people who commit crimes believe they are not going to get caught. So I'm not sure the deterrent effect is really that high.
Right. So this species of asset forfeiture that we're talking about in the specific case of Kim.com here would be the criminal and not the civil asset forfeiture. It bears noting that the current Justice Department has announced that it plans to be more aggressive on the civil asset forfeiture front and all of the hazards of that you were discussing, Tom. Sorry, go ahead.
Denise, I do think that the Kim.com is a civil asset forfeiture
Is it
case.
civil, even though he's been federally indicted?
Yeah, but you can bring them concurrently, and if you look at the complaint, it's not against Kim.com. So one of the unique features of civil forfeiture is it's actually against his asset and not against him. So, so the burden is on him to show that he wasn't a criminal. Now, in this case, it's pretty clear that there was copyright violations all over the place, and he profited substantially by that. But the question is whether the procedure I think that it will eventually come up whether the procedure is constitutional to put the burden on the defendant to prove that they did not commit a crime, that the truck that they were driving down the road was not involved in a drug bust where they were not originally had to be proved that. So I believe the standard, and correct me if I'm wrong, is a reasonable standard that is a probable cause standard for a civil asset forfeiture. So this isn't beyond a reasonable doubt that the car committed the crime, but it is a probable cause that the car committed the crime. So it's the same standard to get a warrant as to it basically impound your car.
Yeah. In this particular case, he has been indicted.
Correct.
So he is charged with a crime. So it's kind of a hybrid, but it does put him in a difficult situation, because if he's going to come back, if he's going to go into court and attempt to get these back, he's got the indictment hanging over his head, and some of the evidence that he might want to introduce perhaps could be used against him in the criminal case. So he's kind of caught between a rock and a hard place.
Yeah.
The interesting twist here, and why I think his cert petition raises some issues that the Supreme Court might want to bite on, is I misspoke early on in giving you background on this, and assumed he might have some assets in the U.S. But no, in looking through the coverage on this while we've been talking, it appears none of his assets are in the U.S. They're in bank accounts in Hong Kong and New Zealand, as well as property in New Zealand. And that he himself has never been to the U.S., never stepped foot in the U.S. So this doctrine that they're proceeding under, the fugitive disentitlement doctrine, forbids defendants from using the court system to their advantage while they're a fugitive from the U.S. This is going to turn on whether, if you've never been to the U.S., can you be a fugitive? And that's basically what he's arguing, and saying that this puts other foreign nationals at risk, because here's what they've argued in their cert petition. One quote from there: if left undisturbed, the Fourth Circuit's decision enables the government to obtain civil forfeiture of every penny of a foreign citizen's foreign assets based on unproven allegations of the most novel, dubious U.S. crimes. So he's saying indictment shouldn't be enough to come after the assets of someone who, like him, has never set foot in the U.S. and to add to that, it appears that none of these assets are in the U.S.
Well, Denise, in some way, this goes back to one of the things I mentioned at the beginning of the show.
Yes.
And that is the criminal activity has changed so much in the last 20 to 30 years with the use of the internet and computers and communications in that way, that people who are remain in a foreign country can in fact commit a crime in the United States, whether it be hacking, whether it be actually conducting business, they can do it. So if they in fact commit a crime in the United States, by that means there has to be some way to attempt to get them and their assets here in this country. Presumably, if they've committed a crime, these assets are in some way linked to that particular crime. And I believe that's what's happening here, although I'm not familiar with the particulars of the case. Now, people say, well, just an indictment shouldn't be enough, but that's the way criminal cases start. You don't really have enough until you've got the conviction, where you prove it beyond a reasonable doubt. But the indictment is the start of the process, and without that, you're never going to get to the end.
Yeah, it definitely goes to what we were talking about at the beginning of the show and how you go after foreign actors using technology to commit crimes in the U.S. and elsewhere, and that's exactly the Kim.com situation. But I do think that he raises a novel and interesting and I think problematic issue for the Supreme Court. If how can you be a fugitive of a country where you've never been? Seems a little difficult to wrap your head around. Do you agree, Tom?
Well, it is because, and in some ways, it's not just the legal aspect of it. There's also politics involved in it, in the asset forfeiture. The Congress has been dealing with it, and in one respect, they're trying to make the civil asset forfeiture more difficult because of some cases where there were abuses. But now, apparently, the Justice Department is trying to say they're going to tighten up on it, and they want to work with Congress in that regard. Someplace along there has to be a balance. And, of course, local governments are interested in it because they get money from all these proceedings as well. And but you have to go someplace to prosecute these people, because otherwise people would be committing crimes all over the country every day without ever having set foot if there are no consequences.
Right. Mike, any thoughts?
I had a question for Tom. I wanted to make sure I understood the relative burden of proof here in the context of a civil forfeiture. So as Matt had mentioned, and it's consistent with my understanding, civil forfeiture is a proceeding by the federal government it's an in rem proceeding, meaning it's against the property as opposed to the person. So in the mega upload example, it's not against Kim.com, it's against his property. And did you say, Tom, that the burden is on Kim.com in the civil forfeiture, or does the government have some burden of showing that this particular property, that it's more probable than not that it was used or the fruit of a crime?
Well, initially,
can you clarify that?
Initially, the burden is on the government to show that there is cause to seize this particular property. Once that burden is met, then it would shift to the defendant. And this is a big debate that was going on in Congress, and the present Congress and Senate, I don't think, has spent much time addressing it, but the burden has been by a preponderance of the evidence, and some change in legislation would make it by clear and convincing evidence and would place the entire burden on the government. Now, what is going to happen with that, I don't know. It's all part of the controversy that will be, I assume, picking up when Congress is now that they're back in session.
Got it. So when a proceeding is started, take, for example, the mega upload civil forfeiture, the government had to have probable cause, I guess, to seize these assets, and then it starts the civil proceeding. And is that civil proceeding essentially saying to the defendant or the property, essentially it's now your burden to prove that this property was improperly seized by the federal government?
Well, yes. First off, they would have to show an interest in the property. And there are many situations where the government can seize something in a civil asset forfeiture and nobody actually comes forward to claim it. I'm aware of one particular case where a tractor trailer came across the border from Canada, and there was cause to believe that it was hauling drugs, and after coming across the international border, it was stopped some distance down the road. The driver didn't have a key to the truck, to the trailer that was locked. He had just been hired to drive and really said he didn't understand what he had, but they opened it up, and there was a couple $1 million in cash in 5-gallon buckets in the back of the truck. Although the police had a suspicion as to whom that money belonged to, They provided them notice, but nobody ever came forward to claim it, for fear that they would then be linked with the drug operation. Right. And that will happen sometimes.
Matt, I know you've been deeply interested in this issue. What do you want to know more about from Tom?
Tom, what is the feeling within the prosecutor's office about the sort of conflict of interest that comes about when the government is the specific agencies who are prosecuting these civil crimes are getting a cut of the essential profits from bringing these charges against them?
Well, that's why it goes into the court system, and they've got to establish their reason for doing it and the good cause. And it's not until it's over that it gets divvied up. There are a few cases that are handled administratively, but those again are cases where nobody has made any claims, and this is some of the abuse that the Department of Justice was seeking to overturn by putting stricter requirements when cases are adopted by the Department of Justice or the U.S. Attorney's offices that initially started with the states.
Okay, I think we are going to take a break for a moment and thank our sponsor for this episode of This Week in Law, and that is Felix Gray. I've been sporting a pair of Felix Grays throughout the whole show. I'm so glad to have these in my life. The last time we thanked Felix Gray as a sponsor, I mentioned to you that I liked mine so much that I immediately got a pair for my husband. He immediately ran out of the house with them and has had them in his possession as he uses his phone and computer screen at his own office. They are specifically designed for making looking at screens a more pleasant experience. You might be looking at a screen right now, or you might be listening to this podcast to get away from one. But regardless, I'm sure that you're familiar with that eye rub moment when your eyes feel dry and fatigued and you have a headache or your vision goes blurry. Well, the reason you might be suffering from that is that screens are quite hard on your eyes. So that is why Felix Gray has developed these wonderful computer-specific glasses that they make. Their lenses are specifically designed to filter blue light and eliminate glare, which many of us know are the two culprits behind digital eye strain. Too much blue light from your computer and phone screen can lead to eye strain and make it difficult to focus. Felix Gray glasses have blue light filtering material embedded into the lens, so they remain effective without that ugly yellow tint that you might have seen or color distortion of other computer glasses. If you want to know more about digital eye strain, be sure to visit felixgrayglasses.com/TWiL to get that information about the dangers of blue light. Felix Gray eyewear is beautifully crafted from premium handmade Italian acetate. Their glasses look great. They feel great. You can feel confident in any work environment. The style that I chose is called Faraday, but they've got a whole bunch of different styles. So whatever your face shape or size, I'm sure if you go to their product selection, you'll find something that's going to work perfectly for you. Non-prescription and reading lenses are currently available, and prescription glasses are coming soon. The reading prescriptions they have range from 1.0 to 2.5. Or, and I highly recommend this if you're not a regular user of readers, you can add 0.25 magnification, just a tiny, tiny bit of magnification if you use your screens a lot. If you're constantly looking at your phone or your computer, just that little bump of magnification will cut down on the eye strain as well, even if you don't ordinarily use reading glasses. All orders include free shipping and free returns, so there's no risk at all in trying them out. Find out which one works best for you by ordering one, putting it on, seeing if you like it. Give your eyes the break they deserve. Go to felixgrayglasses.com/TWiL today to try a pair of Felix Gray computer glasses and discover a smarter way to work. That's felixgrayglasses.com/TWiL. Thank you so much, Felix Gray, for your support of This Week in Law. All right, maybe we should go around the horn once to see that we've fully exhausted our questions and comments about the issue of civil asset forfeiture. And then we're going to move on to one other criminal story and some further stories to end up the show. Matt, anything, any final thoughts on asset forfeiture?
I think that although not perfect, I think that the moves that the Holder administration did were in the right direction, and it's disappointing to see the Trump administration looking to capitalize without due process on the assets of individuals who, even though they may have committed a crime.
All right, Mike?
No further thoughts. Tom, really appreciate your comments and perspective. Fascinating stuff.
And for those, again, looking to learn more about this, we have a piece in our discussion points from July of this year discussing the new administration's policies, their changes in their policy about civil asset forfeiture, their position on it. So if you want a refresher on that, please do go to our discussion points and find this piece called Justice Department Rolls Out New Policy to Seize More Money Under Asset Forfeiture, written up at the Hit and Run blog at Reason. All right, then before we leave Crimes and Justice, I spotted this interesting story that I guess shouldn't really be news to any of us. And again, I guess it sort of ties in with what we've been discussing in that it draws some comparison between what's been going on the Google side and what's been going on at the successor of Mega Upload, Mega, as well as Dropbox. And what this looks at is use of online storage facilities like Google Drive and Mega and Dropbox for illicit purposes. And let's see, Gadgets 360 reviewed a host of DMCA takedown requests from these various services. And while Google had over 5,000 to pull material from Drive, Mega had approximately 100 and less than 12 to Dropbox, interestingly. So people apparently are using their Google Drives. Mega apparently is not being so used, despite its provenance, not near as much. But people are using their Google Drives to facilitate the sharing of things like you might have found on Mega Upload back in its day. And what I thought was really interesting in this write-up at Mashable is that some people have married both Google Drive and YouTube to try and get around Content ID that is designed to pull down infringing material from YouTube. Some people are attempting to upload videos there, make them unlisted, which apparently is algorithmically less dangerous or causing of notice than if you have a publicly available video. And then they would publish these lists of URLs that are not publicly available in a Drive document. And so while you might not be going to Drive to get the material itself, maybe there is where you would find your pointer to YouTube, where you might then find an unlisted file that is an infringing thing that shouldn't be there. So I just thought I had a couple of reactions to this. The first one was sort of course this happens. The second one was that, the more that we succeed in eradicating piracy, the more sort of underground it goes, and it's never going to go away forever. But the fact that it can sort of hide in plain sight like this, I found interesting. Mike, what do you think?
Yeah, I do think it's interesting. Not surprised either. It's kind of like the equivalent of like a digital speakeasy, it seemed to me. I can't imagine that it's going to catch fire like some of these torrent sites do, because isn't this relatively private as compared to some of these torrent sites? It's not as open. The architecture is not as open, it seems. So it doesn't seem to be nearly as problematic, but not super surprised that it happens.
Well, I don't think it has the search capability.
Yeah.
Right. It wouldn't have the search capability that something like Mega Upload or Pirate Bay would have. But if a Google Drive document is as private as the owner of that document wants to make it, they can publish the link to whoever they want to have it, and it can be shared from there. So I'm sure it is a somewhat effective way of alerting people to the fact that you have uploaded infringing material. Matt, any thoughts?
Yeah, I think it's interesting. It seems like kind of a bad strategy, though, because Google's kind of always tracking you. So it seems like they would be able to, if you could find the drive and be able to get a search warrant for the names who have accessed that, it seems like it would be pretty good evidence for who has been there. So it seems like you would get more evidence from Google than you would from other companies, just because they're better at tracking. So just interesting.
Tom, over your tenure as both a judge and a prosecutor, we've seen this real shift away from people using their local devices to, whether it's infringe copyright or otherwise do things that are unlawful, potentially criminally unlawful, to using third-party services because it's more convenient and they get more storage, and it's one step removed from their own device in their home. What do you think about the pros and cons of holding companies like Google accountable for what their users are doing with the tools that they make available?
Well, first off, I would say that as far as technology is concerned, almost all the technology knowledge in my family is held by my son, and I'm not up on some of the mechanics of it. But I do think that any company, regardless of what it is, does need to accept responsibility for the consequences of the materials that they put out there. Now, how that is implemented, I'm not sure. I haven't had the opportunity to have a case of this nature, in any of the cases that have come before me in court or even in the U.S. Attorney's Office.
Mm-hmm. All right. Well, thank you for sharing those thoughts. Let's see. I think we have a second MCLE passphrase to put in the show, and that would be digital speakeasy. Mike, that was fairly brilliant.
That was good.
Yes, it captures what's going on there. Let's move on to talk about a couple of trademark stories. Mike, I've realized I've been paying attention to and even ordering products from an interesting company called Brandless, and that I'd never brought it up to one of my favorite trademark professionals, that being you. So I thought I'd bring it up on the show today. And it was on my mind because of the recent publicity around Amazon and Whole Foods and the changes at Whole Foods due to the Amazon acquisition, and how this startup seems to me a real contender to sort of go after the Amazon / Whole Foods, Targets, Walmarts of the world, because their spin on things is to offer everything on their site for no more than $3. You're not going to spend any more than $3 for anything they sell. And to white label everything. In other words, to get it from third-party suppliers who are not identified by name, but instead are sold under the, as you point out, ironic logo of Brandless.
Yep.
Why don't you tell us more about that?
Yeah, so I'm not all that familiar with Brandless, but as you say, they're apparently well-funded company. I think received something like $50 million in funding recently, and they purport to sell non-brand name white-labeled products. So white labeling is essentially this commercial concept where a third party makes a particular product, and then it's sold to another company that rebrands it or provides its own branding on that product. So that's exactly what these folks are doing. All of their products are not brand name products; they're brandless. And as you had mentioned, one of the ironies here is that Brandless is actually the owner of 10 different trademark applications with respect to its commercial endeavor here. So, it's a great idea. I think there's certainly market demand that people are looking for less expensive commercial alternatives, and so they're obviously feeling a niche. So, more power to them. I think it's great for the consumer.
Right. I've read a couple of reviews of the service, and I've used it myself. The reviews point out, and I think I agree that, it's going to be sort of hit or miss. You're going to find products that you think are an incredible bargain at $3 and that you're going to want to reorder again and again. And then you're going to find, a bag of cookies that seems like, well, gee, I paid $3 for that. You might feel like some might not be worth the cost of admission. But the overall, I think the quality has been really, really nice. I ordered sort of an assortment of things, foods and toiletries and household items, and overall, I think it's a really nice alternative, and I found it fascinating just from the legal standpoint that their positioning is, we're sick of brands, you're sick of brands, you're sick of paying for brands, so don't do it anymore.
Right.
Something. Go ahead.
Oh, I was just going to say, this whole concept of white labeling is really, it's pervasive in every aspect of what we purchase as consumers. There's lots and lots of examples out there. For example, it's a little known secret that the Kirkland brand that is Costco, Grey Goose makes the Kirkland vodka product. So there's replete examples of this happening, where this white labeling process happens, and like I said, I applaud Brandless. They found a niche here for sure.
Right. Yeah, I think that is something that consumers probably don't know that much about, but should know about, that they may be when they shop at Costco or Target or Walmart or wherever, that some of the things that you buy there actually are, we have Mossimo for Target, for example, or, any number of designers that make a specific line for those stores. But there are also things that you are buying there that might be a branded item, like you said, with the vodka, that just, the manufacturer has decided, why would we not want to do business with a huge company like Costco and access that audience and consumer base without harming our brand? We can sell a lot of vodka at Costco, and we can sell it for less than we ordinarily would, but we can still cater to our high-end customers and not tarnish the brand by having it sold at Costco. So it is something that goes on all the time. And then, since we discussed trademarking the color yellow last week in connection with Cheerios and its unsuccessful effort to do that, I thought as we enter into pumpkin spice season here in September that we should perhaps ponder for a moment the notion of possibly trademarking an aroma or a flavor. Just something that caught my eye is that a company called Native is selling, among the various other pumpkin spice things that you are bombarded with at this time of year, not just Starbucks' very popular pumpkin spice latte. Native is making a pumpkin spice deodorant should you need to incorporate that into your life. Do you think, Mike, that Starbucks might have anything bad to say about this, or any sort of legal saber rattling that they might want to do?
Oh, I think that might be kind of tough. There's pumpkin spice just about everything out there, so I wasn't all that surprised to see pumpkin spice deodorant.
Matt, any pumpkin spice thoughts?
No, but I'm just wondering how the natives would have made their pumpkin spice deodorant back in the day. But not too many pumpkin spice thoughts.
No. Okay. Tom, anything you'd like to add to our discussion about brandless and or spicy deodorant?
Well, not about spicy deodorant, but I think the unique thing is about brandless. When I first saw that, and I didn't see it until I looked at this yesterday, was that brandless, I think, will in and of itself become a brand.
Right.
So, but, it looks like they are attempting to build a better mousetrap and may have found a way to do it.
Absolutely. And it's funny, in my own household, I'm not real wedded to brands, or I don't think that I am anyway. My self-perception is that I'm not. So I was pretty receptive to all the stuff that I was trying out from Brandless. But I ordered peanut butter that wasn't our ordinary peanut butter, and I spread it on some toast for my son this morning. And his reaction was, "What is that stuff? Where's the Skippy?" So people do get wedded to what they're used to.
Now, had he seen the label, Denise, or was this kind of a blind taste test?
He saw that the jar looked different than what he was used to. Yes. And then he saw the label and he went, huh? Where's the Skippy? So I don't think that he disliked it, but he knows he likes his Skippy. So I think he's biased. All right, let us move on to a case that we've been following for a while, where there is at least round one of a resolution, and it is under our topic of journalism and the First Amendment and defamation. The lawsuit against TechDirt that was brought by Shiva Ayadurai, if I'm saying that correctly, has been dismissed at the trial court level. TechDirt prevailed on a motion to dismiss that for now throws the case out of court. Shiva Ayadurai says that there will be, counsel for Shiva Ayadurai says that there will be an appeal, which is no surprise, really. This is the case that involves defamation claims against TechDirt, who criticized Shiva Ayadurai for repeatedly claiming to be the inventor of email. TechDirt, and specifically Mike Masnick there, did journalism that took issue with that claim and disputed it and wrote about why Shiva Ayadurai was not the inventor of email as far as TechDirt and Mike Masnick were concerned. And that journalism resulted in a claim for defamation, which has been pending for some time. It's now been dismissed. There, as with all things in the legal realm, the trial court determination can just be step one of the process, and we have heard from counsel for the plaintiff there that they do intend to appeal. So the legal battle there isn't over. The judge in the case decided the issue on the basis that it was impossible to define precisely and specifically what email is. So claiming that you're the inventor of email is not a definitive thing to prove or disprove, and that the court felt that the plaintiff was not going to be able to show that saying the person did not invent email was a falsehood, which you need to prove in order to prove a defamation claim. TechDirt also had an anti-SLAPP motion pending that the judge did not grant, denied their separate motion to strike under California's anti-SLAPP laws. So perhaps that will get looked at on appeal as well, since an appeal does seem to be inevitable here. Mike, any thoughts?
Yes, so this is a really great opinion in my estimation. It's written by Judge Saylor, who's a very well-respected judge there in Massachusetts. I've actually been before Judge Saylor in a couple of cases, and I think he did a great job in analyzing the issues. Interesting that and I forget Shiva. I forget exactly how to say his last name, but what Judge Saylor found with respect to the defamation claim here is that he is a public figure, or at least a limited public figure, for this particular dispute, which means when you're a public figure under the First Amendment, you have to show that there's actual malice with respect to what was reported here. So interesting wrinkle. But I don't know that at the end of the day it would have mattered anyway, for the exact reason that you're saying, Denise, that what Judge Saylor found is, look, email, the concept of email, or what exactly is email, can mean different things to different people. There's not one set universal definition of email. And although Shiva may have created some sort of electronic mail system, the fact that TechDirt was saying he is not the inventor of the concept of email to all people, I think the court got it exactly right. This isn't a case that where a defamation claim should lie. So I think it's great, but of course this will no doubt be appealed to the First Circuit Court of Appeals. So we'll see what happens.
Tom, any thoughts on this one?
Well, I'm going to agree with Mike, and again, this is another area where the law is evolving. But when I first read this, it reminded me of a case that was decided back in the ancient days when I was in law school, and Justice Potter Stewart on the United States Supreme Court, it was a pornography case, said he couldn't define pornography, but he knew it when he saw it. And I think everybody kind of has their own version of what email is. A precise definition would probably be like nailing Jell-O to a wall.
Yep, I agree with you. Online communications are slippery and constantly evolving. There's probably something coming out right at this very moment that we'll all be using next week. Matt, any thoughts?
Yeah, I just think that, this is an example where the cost of defending this had to be astronomical, which is, more or less a frivolous lawsuit about someone saying that, look, no, you did not invent email. And like, even if it's a factual claim, and even if TechDirt was wrong about that, that seems like something that you shouldn't be able to run someone through the ringer for. And the question is defamation one of those things that, as the First Amendment evolves, and the First Amendment is covering more and more areas, is defamation going to be one of those things that's swallowed by the First Amendment? And a court looks at it and says the cost of upholding the defamation law for individuals across the spectrum is just not worth the benefit of protecting people from defamation when we're not willing to say things like this guy didn't invent email, or we're not willing to look at a factual finding of what email was. So I'm sure that if this was a patent suit, we would have been able to find out what email was. It seems like the court may have just slid by that issue because this was an equity balancing that they didn't want to answer that question.
Well, I'm sure we'll hear more about it on appeal, and we'll continue to follow along with the case. For our last topic today, we're going to look. You might not know that this is a copyright issue, but when you spend time in the head of an IP lawyer, of course it is. So I want to show you a bit of video from Mental Floss, the magazine, that features a very entrepreneurial and creative endeavor of making T-shirts out of surfaces, city surfaces. I just think these things come out so cool, and what a creative idea to put, I'm sure it's color safe, washer safe ink on various surfaces around a city, and then put them on bags and T-shirts and various other things. It's like a wood block print, only derived from the cityscape. And I'm sure you could make art out of this as well as wearable items. So in addition to just marveling at the creativity and innovative idea that it took to say, hey, I'm going to make art out of the city, of course, I then started thinking, well, who's going to assert rights about that? And I'm not sure. I threw this in just as one of those angels dancing on the head of a pin kind of things for us to chew on and discuss. Since cities are governments and government property is in the public domain, maybe there's nothing to talk about here, but maybe there is. Mike, some of the things would be installed perhaps by city contractors, but again, maybe the public domain argument would still apply. Any thoughts, Mike?
Well, no, you're right. So there's a meaningful distinction to be drawn, though, between federal property and property owned by other governmental entities like cities, states, and counties. So, of course, with respect to government property, any federal government doesn't have federal copyright protection with respect to works created by United States employees. So, to the extent that any of these works of art that were being created and they were federal property or created by federal employees, I don't think that there would be a copyright claim associated with it. But if some of these works are based on, if some of these T-shirts and other designs were created based on works created by state employees or state contractors, yes, there could potentially be a copyright claim associated with that. But I will say, when I saw the video, I loved it. I thought, what a creative, clever idea, and I hope these folks keep doing what they're doing, because it's tremendous.
The other thing we haven't touched on is whether a texture like this is within the realm of any sort of IP protection. We were talking about aromas earlier in the show. Can you copyright or trademark a texture? Certainly, if your logo is incorporated in the texture, and some of these manhole covers appear to have words and images and things, in addition to just really interesting patterns. Yeah. It's a great. Yeah, it's a great question that's really relevant, and it's kind of right in line with the Star Athletica case, because Star Athletica deals with the concept or the issue of a useful article and whether a pictorial or graphical work embedded within that useful article is subject to copyright protection. And these manhole covers, obviously, they're utilitarian articles, but they do have, as this one on the screen clearly demonstrates, they do have sculptural qualities or graphical qualities to them. So I would say that, with respect to some of these, you can clearly separate out the sculptural or graphical qualities from the utilitarian article. So you could certainly claim copyright protection with respect to the sculptural or graphical component of these utilitarian objects, in my opinion. Yeah, I think you're right. Matt, any thoughts?
Yeah, I think this is amazing. The one thing is that they could also be made by third parties. I know around here we have manhole covers with companies that made them. They have their logo on them. So that's another opportunity for, a copyright holder to assert their rights. But I hope that no one does, because I think this is really cool.
I think we're all in that boat. Tom, what do you think?
I agree with everybody. I think it's it's a new idea. It's better. And just somebody's entrepreneurial about it.
Yeah, I mean, with so much interest in industrial design, interior design concepts, I think could definitely see artworks being generated this way. I can envision redoing the whole living room this way. So good on them, and we wish them well, but encourage them to pay attention to whatever IP considerations may come into play in their burgeoning business. Let's move on to our concluding materials of the show and our animal selfie of the week. Our animal selfie is always a little bit zen, but this one in particular is: please enjoy riding along with a sea turtle on the Great Barrier Reef. Ah, so peaceful, nice. So calm, so beautiful, so uncopyrightable, maybe. Depending on your perspective. So this example, we do have the turtle as cinematographer, but not necessarily a willing one. I don't know how the GoPro was mounted on its back. I don't know. I hope that it was humanely and that it very readily comes off and lets the turtle go on its own way. But the turtle is definitely deciding what we're going to see here, to the extent it has any idea what's going on. And it's doing a good job. So, I mean, PETA might obviously complain about employing a turtle without having gotten its express written or oral consent in this manner. But as far as the copyrightability of the footage goes, I think we'd have to give this one to the person who plunked the GoPro on there, to the extent you could. Mike, any thoughts?
Yep. I would agree with that.
Yes. So, Tom, we do this every week because there are so many people employing animals in either the taking of their selfies, or the animals employ themselves by grabbing people's cameras and then running around with them. And the copyright issues remain somewhat, always fascinating and somewhat unsettled. So we try and bring examples of that to light each week. We also try and feature useful tips each week. And Tom, this week, you've got a couple for us.
Well, there are a couple, and these aren't any great scholarly works, and they're not hugely helpful, perhaps, on technology, but they're rather, I think, common sense tips. And one I think of partly because of what just happened in Texas and what's going to be happening in Florida, is that these types of disasters bring out people who are operating scams of one type or another for to repair or for construction. And I think everybody is just going to have to be very careful, because clearly help to get people back on their feet, help to repair homes, and to replace belongings is going to be very scarce. It's going to be difficult. It's going to be expensive. But you really have to use common sense and beware of anything that you think is suspicious. In all of these areas, as has been shown in the past, there will be people coming in from outside, from other areas, and it'll be difficult to check out their backgrounds and what type of work they might do. Ordinarily, if you hire somebody to do some work around your home, you might be able to get a reference from a neighbor or some customer in the area where you live, but it's going to be very difficult here, and you just have to be using your common sense, and I think be suspicious under the circumstances, and be aware of prices that may have been inflated under the circumstances. And I don't know specifically what the law is in Texas or Florida, but I believe almost every state, if not all of them, have protections for consumers, and there is a maximum amount of money that you have to put down as a down payment or to advance for supplies. So just be careful, and I wish everybody well. The second thing is a tip to some trial lawyers, and this could be for brand new trial lawyers or ones with a lot of experience. And I've seen this happen any number of times, where people are caught up in the issues of their cases and getting witnesses ready and preparing for trial. But many times they don't go far enough in preparing, and that also includes knowing the courtroom and the courthouse where you're going to be trying the case. There are many courtrooms that today have the technology that is necessary for you to use everything, including PowerPoints and all kinds of other gadgets. But many times you're going to be trying cases in courtrooms that haven't seen any major repairs for perhaps 100 years. We have some of those in rural Maine. And when an attorney comes in and is not familiar with that particular courtroom and wants to use something like a PowerPoint, it's rather embarrassing to be standing in the well of the court in front of the jury and the judge and maybe half a dozen spectators, and you're holding an electric cord that you want to plug in, and you're looking around and you can't find the socket for it. It just kind of, I think, lowers the opinion of the jury when they think how much time you spent preparing the case, and maybe it's not that important. But those things do happen. And even this goes back to when I was first a judge in a rural court. The original technology for presenting evidence in court, the chalkboard, and the attorney went over to the wall, and the chalkboard pulled out from the wall, but he hadn't checked the hinges. It fell on the floor. The slate cracked. It was just embarrassing for everybody. But those are little things that you can do to just make sure that you're really prepared.
All right. And our resource of the week, thank you so much, Tom. Those are both great tips. And it occurs to me with respect to your first one, not only to be, people should be on guard about being gouged but in pricing, but as Tom is pointing out, unfortunately, people may take advantage of you in any number of ways. You should probably be on the look for things that are priced too good to be true as well. Just, as he said, use your common sense. And that you probably want to use your common sense with respect to if your data was caught up in the Equifax hack. And we wanted to give you some resources for how you might go about doing that. The one resource that I'm going to give you comes with a caveat, and that is the page that Equifax has established to alert you or give you some insight into whether your data may have been included in the hack. In order to do that, you have to put in the last 6 digits of your social security number. So a lot of security researchers are scratching their heads and going, okay, so you're asking for my social security number to see if my social security number was compromised. That seems a little counterintuitive, but okay. So if you're willing to give them the last 6 of your social, they will give you either an all clear or a cryptic message that says your data may have been compromised, and then it steers you toward a program that it is offered called Trusted ID Premier, which it is offering for anyone who they think their data may have been compromised. It's free for a year, and it is a credit monitoring service. But the huge caveat here is that if you agree and sign up for Trusted ID Premier as some sort of a bone that's being thrown your way from Equifax as part of this hack, you are opting yourself out, waiving your rights to participate in any sort of litigation over this. The site's terms of service for Trusted ID Premier have you agreeing to mandatory arbitration of all disputes concerning your use of this service. So be wary of that. There is already a class action pending. So if you do not want to waive your rights, do pay attention. This is one of those times when you should read the terms of service and perhaps not opt for Trusted ID premiere. The other thing that I've seen about this, the LA Times is suggesting that you may want to contact all three of the major credit bureaus and request a credit freeze. There may be a fee for that. It says there's a $10 fee for that in California. There may be fees in other states, but that would prevent a hacker or anyone with access to your data from manipulating that data if you do put a freeze on it. So that seems also like a wise idea. So those are our resources of the week. And that is our show. We thank you so much for joining us this week. Tom, I just can't tell you how wonderful it's been to chat with you this time. We're so glad that you've had the opportunity to join us on the show.
Thank you for the opportunity to be here. I appreciate it.
Is there anything that you'd like to, you've already given us some great tips, but anything you'd like to point our listeners or viewers towards, anything you'd like them to pay attention to just as we're signing off here today?
You can have a lot of technology, knowledge, but common sense can't be replaced.
Thank you so much. That's been Thomas E. Delahanty II, former U.S. Attorney for the state of Maine, and our very great honor to chat with you today, Tom. And my very great pleasure, as always, to chat with my two co-hosts, Mike Keyes in Seattle. Great seeing you again, Mike.
Denise, that was great. Tom, thanks so much for being with us today. That was terrific.
Thank you.
And Matt Curtis at Notre Dame, slogging away in the trenches of law school. Hope everything's going great with you, Matt.
Yeah, everything's great. Thanks so much for joining us, Tom. It was wonderful. I do have a little recommendation. I got to go on a architectural tour in Chicago last weekend, and it was just fantastic. If anyone gets there before the summer's over, I recommend going on there. It's pretty spectacular.
Ooh, that sounds like something where you might want to bring some T-shirts and rubbing materials.
Yeah.
Copy the designs of the architecture of Chicago.
Really big T-shirts.
Yes, really, really big T-shirts. That's great. Thank you so much, Matt. Thank you all for joining us on this episode of This Week in Law. We record the show every Friday at 11 o'clock Pacific Time, 1800 UTC. We'd love it if you can join us live, but don't worry if you can't. Our entire archive of shows is available at twit.tv/TWiL, going all the way back to the beginning of the show, which is about to turn 11 next month, if you can believe it. So we've got lots and lots of archives there for you to enjoy at your leisure on your device of choice. There are also instructions on that page for how you might want to enjoy the show technologically, whether you prefer it on a small screen as you go about your day, driving around in the gym, etc., or on the big screen as you're kicking back at home. We are consumable in all of those ways. And you can use your device of choice with some guidance there from our show page onto how you can do that. And we love hearing from you between the shows. Please do get in touch with us. Let us know what you thought about our discussions, things that you would have added to the discussion if we did not already pull your comments out of chat. That's one of the benefits of joining us live, is we do play along with the audience in our live IRC chat. So if you want to get on the show, that's a great way to do it. Heckle us and help us during the show, and we'll try and feature you if we can. Or if you email us between the shows, we'll definitely feature you that way too. I'm Denise at twit.tv. Mike is Mike at twit.tv, and Matt is Matt C at twit.tv. If you want to email us, or you can find us on Twitter, that's where I'm D Howell. Mike is J. Michael Keyes there, and Matt is Law Pint there. How's the Law Pint podcast going, Matt?
We've got 2 new ones coming out this weekend, so it should be good. We've got one on school choice, which is an interesting topic that's likely to come before the Supreme Court. And then we've got another patent one, which should be really interesting.
Wonderful. Thanks for the update. Do get in touch with us on Twitter, on Facebook. If you'd like, you can have a little bit more room to comment. Let us know what you thought, what was in your head, what guests come to mind that you think we should invite on the show. We'd love hearing from you. Please do keep in touch, and we'll either hear from you before the show or hopefully see you next week when we record next on Friday on This Week in Law. Until then, Take care.